Namaskar. You would have noticed that every time we have discussed any aspect of legal theory or any particular legal theory, the choice of the theory has been dictated by the context. This module that we are starting out is on law, power and justice across legal context. And there is a dynamic between law and power and justice, that is, people who are in power dictate the law, and hence to what extent are we furthering justice or avoiding injustice remains an issue which is problematic. We needed a theory which addresses this question very centrally. It sees the connection between these three concepts and provides us insights on how we should be discussing or observing or deducing the dynamics in the various contexts that we are going to be discussing in this module. For me, feminism fit the bill, and it's for that reason that I have chosen feminism or feminist engagement with power and oppression as the theoretical exposition of this module. I begin this presentation by firstly dwelling on or deliberating on why feminism. I next speak about the various developments in feminist thought which are of special relevance or significance to the issues that we are discussing in this module. And lastly, I talk about the all-pervasive presence of gendered understanding, which requires all us law teachers, irrespective of which particular area of law we specialize in or we teach, to engage with questions of feminist thought. Why feminism? I have chosen feminism for this module because this is one body of thought which doesn't only addresses questions of law, power and justice externally. That is, it doesn't just look at normative structures or institutional structures in the world outside and demonstrate what is not right with them. It does as much. It turns its gaze as much inwards. It reflects upon, you could say, the various theories of feminism and tries to ask this question that, okay, how do these various theories address issues of law? I wouldn't say necessarily law always, but definitely questions of power and justice. It is kind of somewhere challenges any grand narrative. I'll explain. Let's look at liberal feminism. Liberal feminism was asking for women to be treated the same as men, and saying that once you do that, if you are going to be treating us the same as men, all questions of injustice meted out to women would be met with. The fact that women could have different needs, and the fact that the fact that you were giving this kind of primacy to the male standard was not something which was appreciated in liberal feminism, and that became the challenge against it. We moved from there to radical feminism, which was then saying that no, we are going to be looking at the needs of women unmodified by Catherine McKinnon and other radical feminists who are somewhere saying let's go back to the roots, let's start to construct what is required by women by women uncluttered by how patriarchy looked at them or looks at them. The difficulty that you ran in there was you were essentializing women. And the kind of challenge which came was that if you are going to be essentializing women in this manner, then the other dimensions of her personality and her identity is being given the go-by. So whether it was, women of race, whether it was women who were indigenous women, whether it was women with disabilities, women with non-heterosexual orientation, all of them started to say, we don't see ourselves in this particular version of feminism that is being put out as a grand narrative. See, this critique which came from inside of feminism, not from outside, led to them developing or evolving what you can term as feminisms. And these internal critiques and these multiple explanations emerged in a kind of a political environment where all of them were given a non-hierarchical acceptance. You were not saying one brand of feminism is more or less than the other. And it's this diversity of feminist thought, this ability to be able to critique both outside and inside, has been my reason for why I think that when we are starting to speak in terms of or worry about questions of law, power and justice, we need to specially look at this body of thought. The second thing which I want to be spending time with you on is the particular developments in over and above this development of or moving from feminism to feminisms. There are at least 3 other ideas of feminist thought which I want to focus attention on. The first one is to do with this very intimate connection that feminism saw between power and knowledge. That is, what you consider to be legitimate knowledge or valid knowledge, or gave it that recognition and standing and stature of knowledge, came from people who were occupying positions of power, be it professionals, be it senior academicians, be it theorists, be it scholars. Who were the people who were getting that kind of opportunity or could go through a certain set of process by which you say what we have thought of should be considered knowledge? That is one connection which was brought out, and consequently, if you as a woman were not getting the opportunity to be occupying those echelons of power, necessarily you couldn't be a producer of knowledge. So what feminist thought started to do is fundamentally questioned this way of producing knowledge. They started to provide, firstly, provided credibility to experiential knowledge, provided credibility to the narrative, to say that what I have experienced or what I am narrating, my story, is as much authentic knowledge as something which somebody has found through some very objective processes which you call. How objective they were is the other part of the critique. So you could say there was this very major demand for epistemic justice, that is, the opportunity to be able to produce meaning and for your meaning to be given seriousness, was one very major contribution which came in from feminist thought, of special interest and relevance to us as law people, because interpretation and production of meaning and modification of meaning is a very critical task that we undertake all the time. The second major contribution, or the second major development which happened in feminist thought, some of which I have already touched upon when I spoke to you about moving from feminism to feminisms, is that they did not, the critique that you couldn't understand women as one unvariegated category, that you can't say that all women are the same, irrespective of class, caste, race, region, religion, disability. All of these have an impact on the kind of woman you are. So you can't think or talk of women as one unvariegated category. If you try to do that, then what you'll end up doing is one set of women, possibly who wield greater social power, appropriate the voice of the other, and this necessarily, for a school of thought which was challenging oppression, was not acceptable. It's like I cannot challenge the oppression of the other and be an oppressor myself. So they questioned these claims of unique identity, and that's wherein gave birth to or started to speak about, which is the third concept I want us to focus attention on, to speak of intersectionality. Intersectionality meaning that you were constituting identity in a more complex kind of manner. So when you speak in terms of, say, a Dalit woman with disability, you are acknowledging the fact that she is not just woman, she is not just Dalit, and she is not just a woman with disability. She's all of these three. And if she's all of these three, then the discrimination she experiences under each of these three categories need to be taken note of. We need to be worrying about them. We need to be addressing them. Simultaneously, the very fact that she occupies more than one identity space, you also have possibilities of creating bridges of solidarity. You can enhance social capital in a certain kind of manner, which wouldn't happen when you speak in terms of unique identities. And this is you could say, the third major contribution which comes in from feminist thought. Now, how do we take these insights of feminism to law? How does it speak to us as law teachers? One thing which evidently comes through is that there is no area of law which is not gendered. From taxation to corporate law to intellectual property to international law to tort to crime, you name it, and you would have to be confronted by the fact that there is a gendered understanding prevailing there. It's like it happens in various kinds of ways. One way in which it happens is, say, when you define the primary player in that particular field or that area. Say, when in taxation we talk about the assessee, and we presume that the assessee is a man. So the whole range of, you could say, organization of norms is happening accordingly. I remember there was a case which I used to do in my interpretation class, where they spoke in terms of that with the assessee, which clubbed the income of the wife with the income of the assessee if the wife was dependent on the assessee. So when you had a situation where the assessee was not a man but a woman, and the husband was dependent, the tax department found that they could not really club their income because they had used the gendered terms and they had spoken not in terms of a spouse but a wife. I'm just giving this to you as an example of how this so-called technical area or of taxation is also a gendered enterprise. You have the presentation which is coming in corporate law in terms of who do we think to be a director, how are corporations made, who are the people who are big players there, and how absent of non-male or non-men in that entire marketplace is something which comes through. How do you look at work? We don't look at the work that the woman does in her home, which keeps everybody together, which is wherein as work, because it is not employment, it is not paid or waged work. You want to not give it the recognition of work. You look in terms of motor accidents. And if it's a woman who is a home worker who gets either killed or injured in that accident, you do not give her a commensurate or an equal kind of compensation because she is not an earning member. So your entire calculation of compensation is happening in monetary terms. The other contributions that the person is making is not being acknowledged at all. I'm giving you these varied kinds of examples primarily to be demonstrating that you cannot escape gender. Doesn't matter which field of law you are teaching, and if you escape it, if you sort of like try to talk in terms of grave and sudden provocation in criminal law, as if to say that's the only way in which everybody reacts, and not recognize that it's a male psychology which is being put in place. If you are teaching tort law with believing that the reasonable man and the reasonable woman are the same, and standards of reasonableness have been evolved in the same way for both, that too becomes problematic. I have given you a range of examples across areas. The reason for doing that was to alert you on the gender dimension of areas which I have not covered, but which may be covered in either this module or in the videos that we may do in subsequent modules. I'm hoping that this particular conversation that we are having would would get you to see those gendered, whether it's the gendered constructions or definitions or gendered concepts that have been inducted into the law. And in your pulling out or perceiving those particular concepts, you start to look at the construction of law, power and justice, not in the standard form, not in the stereotypical, but in a critical manner and a critique which you are developing, which is you. Thank you so much.